It's a good question as to whether or not Article 51E isn't the most written about provision of the New York Convention. It probably is. It was originally designed to get around that double exequatur problem of the Geneva Convention that didn't really exist. What the Geneva Convention did say was that you couldn't enforce an award while an award could be set aside in its place of origin. And Article 51E seeks to get round that. The idea behind it makes perfect sense, because you can have a perfectly valid looking arbitration award that is then subject to an application to set aside, which is frivolous, which is designed to waste time. And in that situation, it makes perfect sense to allow an enforcing court to just get on with it and not wait for the decision of the court on the setting aside proceedings. The first part of Article 51E is relatively uncontroversial. It talks about the award has not yet become binding on the parties. Final was the term used actually in the Geneva Convention. What this really means is that you look to the arbitration agreement to see if there's any reason that suspends the award, because if there isn't, it's become binding on the parties. An obvious reason to suspend the award might be a time lag feature which allows for an appeal to a second tribunal against the original decision. By and large, that part of Article 51E hasn't caused many problems. The second part of Article 51E has created difficulties, has been set aside or suspended by a competent authority. Let's start with the easy bit first. Suspended by a competent authority has to be a court, not a legal system. So a provision of a local law that says the award will be suspended during the pendency of any setting aside proceedings will not operate to give the defendant a defence under Article 51E. The more tricky question concerns set aside. The SE in Yugoslavia case became legendary on this one because the Swiss court, before the New York Convention came into existence, refused to enforce the award, gave the award back to the SEE company, which had sought to enforce it, saying that it wasn't an award rendered under the law of the Canton of Vaud because of certain problems with the arbitration agreement. The issue became, in the Dutch courts, whether or not the Swiss court had set aside the award. Well, actually, the Swiss judgments are very clear. They did not set aside the award. So Article 51E should never have been used by the Dutch Supreme Court to refuse enforcement of this award. Ultimately, the award was enforced in France, although history will never recount as to whether or not the liquidator of SEE ever got the money that he was effectively awarded in 1956 following the court judgments in the 1980s. The more controversial question concerns whether or not the setting aside of an award bars enforcement. As I said earlier, Article 5 doesn't lay down a requirement to refuse enforcement of the award in the event of the various grounds being proved. In fact, even the most absolutist reading of Article 5 in terms of compulsory grounds for refusing arbitration award enforcement collapses a bit when we talk about waiver. An obvious example of waiver would be if there was a problem with the arbitration clause. If one party defends on the merits without raising any objection, then they will have waived their defence under Article 5(1)(a). And virtually everybody accepts that. Well, if that's the case, then it must be true that it is open to a contracting state to enforce an award that has been set aside in its place of origin. And Article 7(1), of course, allows local law to be more pro-enforcement than the Convention. The French in Pay-Balken-Norse law accepted this argument in the early 1980s. And the French courts ever since have relied on the fact that there is no defence to enforcement in French law, that the award was set aside in its place of origin. But the subject has become broader in more recent times. Now we're concerned with whether or not we should refuse enforcement of awards that were set aside by crooked, corrupt, inappropriate, don't want to say it, stupid courts who are not applying their own law accurately or applying laws that shouldn't have been allowed in the first place. A consensus is forming in this area amongst countries that don't have a specific provision providing for enforcement of awards set aside in their place of origin. That consensus is that you don't recognise a setting aside if you wouldn't recognise such a judgment under the ordinary rules for recognising and enforcing foreign judgments. So, in the UKOS case, the Dutch courts enforced an award that had been set aside by the Russian courts, whom they considered to have been corrupt. In the US, there have been a number of cases where it has been attempted to enforce awards set aside in various countries, with sometimes quite variable reputation for arbitration. The courts have been prepared to consider whether or not the setting aside judgments meet the public policy standards for enforcement in the US, and indeed anywhere else in the world. And that's starting to become something of a consensus under Article 5(1)(e). In practice, of course, there is nothing to stop a country like France from producing a law that says the defences to enforcement are the following, and then leaving out set aside in the place of origin. This, though, did generate a somewhat unusual case in England in the 1980s. In that case, an award was enforced in France while setting aside proceedings were going on in England. These setting aside proceedings were brought under what is now Section 69 of the 1996 Act, on the basis that the arbitrator had made an error of law. In an unreported case, the English High Court granted an injunction to stop enforcement. I'm pretty sure that injunction breaches Article 7. After that, we're left with Article 5(2), relatively uncontroversial in practice. Recognition and enforcement can also be refused in the event that the award covers a subject matter which is not capable of being arbitrated under the law of the enforcing country. And the second one is that recognition of the award is contrary to public policy of the enforcing country. One thing you should note about the second part, that's 5(2)(b), is that it's the recognition and enforcement of the award that must be contrary to public policy, not the award. In a case decided in the 1980s, DST and Racoil, an arbitrator applied a non-legal standard in a situation where an English court wouldn't allow it, had an arbitrator done so in England. The court took a look at the award and didn't see anything terribly offensive about it, and so enforced it. They also accepted that the arbitrator had applied the agreed rules, on this occasion, the rules of the International Chamber of Commerce. Otherwise, one of the bigger issues in arbitration generally is the absence of a properly catalogued list of non-arbitrable subject matters. It really is a bit of a disgrace that no country, as far as I know, has ever come up with a proper list that's exclusive. It is about time that countries in the developed world produced a proper list of the subject matters that cannot be arbitrated in their countries. There is continuously a risk that parties may agree to arbitrate disputes that cannot be arbitrated in the seat of arbitration, or that one party may seek to enforce an award in another country only to discover that the subject matter is not capable of being arbitrated there. It is really a task for the big four countries of international arbitration, England, France, USA and Switzerland, to come up with a proper list from which other countries can develop their own.